The future Cybercrime Convention is structured into 8 chapters and a preamble, which states the purpose of the document. Core disagreements are centered around key chapters on criminalization and international cooperation. This is because some countries propose to criminalize a sweeping amount of conduct well beyond that of any current international or regional instrument. Others also point to the pitfalls of a wide scope of criminal offenses in practice, such as duplication of already existing provisions. Cybercrime inherently captures complex issues, and without an agreed definition, the discussions will spin between cyber-dependent crimes and cyber-enabled crimes. Cyber-dependent crimes mean offenses that can only be committed using computer systems. And cyber-enabled crimes cover offenses that can exist offline but are enhanced with the use of technology. The second group covers crimes that are already included in other instruments, and many countries believe that existing frameworks are comprehensive enough. An attempt to include a wide scope of cyber-enabled crimes would create the risk of conflict with existing international law and norms. A key concern is that the inclusion of such crimes will introduce standards that conflict with states' international human rights obligations. While disagreements remain concerning the scope of the crimes in the Convention, and therefore to a large degree the Convention itself, there are also other discussions and negotiations around international cooperation which have proven to be difficult and complex. Cybercriminals operate across borders, and as a result, international cooperation needs to be at the core of any investigation or prosecution. Still, a key question is whether international cooperation should be limited to the list of cybercrimes outlined in the Convention, or whether international cooperation should be open to other crimes, for example, serious crimes, and how should those be defined? The aim of this process must be to draft a convention that can serve as a practical tool for timely and rights-respecting investigation of cybercrime. Any resulting convention will only be efficient if its scope and if its obligations and its safeguards are defined narrowly and clearly, and ideally if they are agreed upon by consensus.